Allergies are bad. John, did you change cologne?
This hearing may sound routine at first, but the details tell a much heavier story. Two separate felony cases, both involving assaults on public servants, a long criminal history stretching back decades, and a defendant whose responses immediately raise questions about comprehension and accountability. Judge Stevens is faced with a familiar but difficult balancing act, enforcing the law while navigating mental competency, plea negotiations, and prior revocations. What looks like a straightforward plea deal quickly becomes unpredictable. And as this hearing unfolds, you'll see just how fragile courtroom agreements can be when understanding breaks down at the worst possible moment. Stay with us, because this case does not go the way anyone initially expects.
And 24 CR 2053, and these are both third-degree felonies of assaults on a public servant. And it looks like that you assaulted psychiatric the technology personnel and a corrections officer at the Jefferson County Jail. And these are two third-degree felonies, Ms. Rubin. You are here with your attorney, Mr. West, and the state's attorney. Does the defendant waive a formal reading of the indictments and the arraignments here? Excuse me. Can we proceed in summary?
Yes, Your Honor, please.
In summary, 1926 alleges that on or about August 21st, 2024, in Jefferson County, Texas, you punched a lady in the face with your closed fists who was a public servant, namely a psychiatric tech person lawfully discharging her official duties. In 24 CR 2053, this third-degree felony alleges that on or about July 22nd, 2024, that would have been a month before the previous case number, that it is alleged that you assaulted a public servant, namely a corrections officer at the Jefferson County Jail, lawfully discharging her official duties as providing inmate security. Hold on. And Ms. Rubin, these indictments also state that you are an habitual felon. You were convicted of forgeries 40 years ago. In 1981, out of the 252nd District Court next door. After that was final, it is alleged you committed aggravated assault and were convicted of that in 1994, which would be about 30 years now ago in this criminal district court. So all of this translates to you are looking at no less than 25 years imprisonment up to life imprisonment as an habitual felon. However, I don't think that's what the deal is going to be on these cases.
This is a crucial legal moment that's easy to miss. When the judge explains habitual felon status, he's not threatening, he's warning. Because of prior felony convictions, even older ones, any new felony above a state jail level can legally expose the defendant to 25 years to life if enhancements are used. That's why the clarification here matters so much. The state agrees not to use enhancements, reducing these charges to third-degree felonies with a sentencing range of 2 to 10 years each. That decision alone dramatically changes the defendant's future. This is how plea negotiations quietly shape outcomes long before a verdict is ever reached. Let me ask you, should decades-old convictions still carry this much weight in sentencing today?
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In each case, in addition, a fine may be assessed not to exceed $10,000. Do you understand all of that, ma'am?
Do you understand?
You talked to him about it?
Yes, you understand what you're doing here, correct?
The agreements have been you will be pleading guilty, sentenced to 3 years in prison, and given credit for all time you have served in jail.
Yes.
And these would run concurrently. Is that your understanding? Okay. If I follow these agreements, Ms. Rubin, you have no right of appeal of your cases. Do you understand?
Well,
Talk to her, John. She's asking you a question. Thank you.
He's third morning working in jail. And him and Mr. Synagogue.
Okay. The question is, you understand what's going on is what he's asking. That's all we're doing today. Yes.
Stay together.
How do you plead? Do you plead guilty to these, ma'am?
No,
She says no. God bless her.
I don't.
Did you? Okay. Okay. Oh, no.
This is where the hearing teeters on collapse. Everyone in the courtroom believed a plea agreement was settled. 3 years, concurrent sentences, credit for time served. Then the defendant suddenly says, no. That single word brings everything to a halt. The judge isn't frustrated. He's trying to determine whether the defendant actually understands what's happening. This isn't about guilt or innocence anymore. It's about competency, communication, and consent. A plea must be voluntary and knowing, or it's invalid. You can hear the court slow down, repeat questions, and shift toward a no contest option just to keep the process legally sound. So here's the question. When confusion enters the record, should courts stop entirely or adapt like this to reach resolution?
Already?
She was on the other offenses that she did. She was revoked on. She was revoked for 5 years on the other cases. But these new offenses are the basis for the revocation.
Okay.
Hearing on that.
Well, these are not aggravated, so she ought to be out.
Yeah, they should be.
She ought to be, when you should be released here in the next few days, okay?
On these cases, but the other ones.
On these cases,
but
but
the
you
other
have something else in this?
No. I'm saying she might be held longer on the other case. I don't know when her time's up on the 5 years.
She does have some time.
She was given 5 years in the other cases, so I'm not sure.
When did we do that?
10-14.
Yeah,
When?
10-14.
about a month.
Last month?
Yeah.
And these were the basis of that
Because
revocation.
I remember her, and it was 4 weeks ago, but.
Yeah,
Yeah.
so I'm not going to give her a
So
hope.
these are the other,
Situation for.
these are the other 2 cases that are left here that we're taking care of, okay, Ms. Rubin? Do you understand?
Okay.
So how do you plead guilty to these 2 for you didn't assault these people? You didn't strike these people? What'd she say?
She said, I don't remember. This is the one we had mental evaluation, but Dr. Pond said she was competent, but we.
Yeah, I understand.
I know.
What do you want to do?
I-
She's not going to plead guilty. There's nothing I can do about it.
Let's try it.
Why don't you talk to her? Stand by. Yep. The Dr. Rapon had evaluated her and
Yeah.
deemed her to be competent.
Yes.
And the court will accept a no contest plea if she agrees to that.
She says she agrees to that now.
Are you pleading no contest?
What's no?
Okay, let me try it again.
Yeah.
No contest means you're not saying guilty, not saying not guilty. You're just saying you won't get this over with and take the deal.
Yeah.
Okay, so we ask you, say yes.
Yes. Yes.
Is that what you want to do? No contest?
Yes.
All right. Do you understand that, no, you're not admitting guilt, but if there is additional evidence that supports this, then you can be found guilty, and then I will follow the agreement that y'all have reached, okay? All right. As to these 2 charges, do you plead no contest? Yes or no? Yes. Are you pleading no contest voluntarily and because of the discussions you had with Mr. West here? Yes. Do you understand that a plea of no contest, if there is evidence admitted, and I think we're about to deal with that, that still means you could be found guilty and be sentenced, but the court is going to allow you to plead no contest rather than guilt if the evidence supports guilt, and I will follow this agreement of 3 years to run concurrently that everybody has reached with you, okay? That's what you would like? Yes, ma'am. All right.
Yeah, I think we agree. This was the basis. Yeah, we did. Both of them?
These are third degree felonies, correct?
No, at least put one on. That's correct, Your Honor.
Okay. And these are third degree felonies, which means you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed in each case.
Jesus.
Do you understand, Miss Ruby? God bless you. See your signature. And the agreement is you would be sentenced to 3 years, run concurrently on each case, and be given credit for all time you have served already. So we can get you out of here and go get you home maybe for Thanksgiving. Where are you going to live when you go home?
Well, I will try to get my pet back.
Uh-huh.
And right now, I go to the Social Security office and do my papers all over. All I need is a payee. But all they do is take my money.
On both of these cases, I'm going to show you what's marked as State's Exhibit 1. Did you sign those documents? Is that your signature, Miss Rubin? Okay. Did you discuss all of this with Mr. West, and is everything true here? Yes, ma'am. Okay, thank you. State's Exhibit 1 tendered into evidence without objection admitted. This states that you are mentally competent to enter your guilty pleas, which are no contest pleas, which are entered voluntarily. There is sufficient evidence supporting your no contest plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Okay. State's Exhibit 1 in each case made a part of the record. Pre-sentence reports are waiting.
Please, yes, Your Honor.
I'm going to follow these agreements and find you are pleading no contest voluntarily, knowingly, intelligently. There is sufficient evidence from State's Exhibit 1 admitted here to support your plea of no contest to find you guilty beyond a reasonable doubt. And what the court is going to also take notice of are the probable cause affidavits that have been filed in each case without objection for the court to take in, which supports your no contest plea. I now find you guilty beyond a reasonable doubt in each of these cases, and I am following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas.
In the end, the court carefully threads the needle. After confirming competency evaluations, reviewing evidence, and ensuring the plea is voluntary, Judge Stevens accepts the no contest pleas and formally finds the defendant guilty beyond a reasonable doubt. The final sentence, 3 years in prison on each case, running concurrently, with full credit for time served, reflects both accountability and restraint. These were serious assaults on jail and medical staff, but the court also recognized procedural fairness and mental health considerations. This case is a powerful reminder that courtroom justice isn't just about punishment. It's about process, clarity, and lawful resolution. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.